Good morning. Tip number 18, Transfer of Property Act. Transfer of Property Act was introduced in India in the year 1882 by consolidating the common law process prevailing all over India. Somewhat it is codification of law. This Transfer of Property Act is based upon a maxim nemo dat quod, non-havet, non-havet. That means you cannot transfer the property which you do not have. Do not have means you have no right. So this Transfer of Property Act speaks about two kinds of properties, three kinds of properties, two kinds of properties. Major is immovable property and movable property. Movable property is tangible and non-tangible. Tangible is visible, non-tangible is not visible. Checks and other things. So far, immovable property means permanently attached to the earth. It does not include standing timbers, growing grass and crops, because it is being harvested. Then question of instrument. Non-testamentary instrument will not come under Transfer of Property Act. Instrument means deed, execution of any document. Non-testamentary means except will. Will is a testamentary execution of document. Attestation is most important. Attestation, testimonium. That is called most important provision in the Transfer of Property Act. Two or more persons seeing that the executor, the document who executes, signs in his presence, having seen that two persons have to attest, and there is some other blind persons and Parda Nashini woman how to execute their execution being attested. Then attached to the earth, sometimes it is movable property. Trees and shrubs permanently indented in the earth, like wall, building, etc. And permanent big machines permanently attached with the land. If it is separated, then it will be a movable property. If it is not separated, it will be immovable property. Then question arises, actionable claim. Actionable claim, any debt other than the mortgage, pledge or hypothecation. This is another important notice of the notice, which you must understand, read and keep it in mind permanently, because this would help you everywhere in civil suit as well as criminal cases. Ignorance of facts is executable. Ignorance of law is non-executable. This is of the notice where ignorance of facts is also not executable. A person said to have notice of certain fact means he actually knows about that fact, or he willfully abstaining to know that, search that, or inquire that. Therefore, he will be treated as that person knows the fact. Suppose if somebody is selling the land without knowing the ownership and title of the land, without taking diligent search, if you purchase, you are purchasing the property at the risk, because you are of the notice that this property is belonging to somebody else. Major thing was this Transfer of Property Act is between the inter vivos, living persons. So living persons is defined persons, companies, so many things you go through the act. That has to be a living person is conveying the property, transferring the property to other living persons. So that is called. Then what I have already 1,000 times told, that so far Contract Act is concerned, the competent to contract has to be muck up by you, because everywhere the competent to contract will be reintroduced in act. Like that, Transfer of Property Act also states that who can transfer the property, the person who is competent to contract can transfer the property. This is today's tip. Best wishes.